My name is Stephen L. Mikochik. I'm a visiting professor of law at Ave Maria Law School and an emeritus professor of law at Temple University Law School in Philadelphia. Originally, my topic was comparing John Locke and John Paul II's concept of the nature of work with the link of the U.S. Supreme Court's decision. We thought it might be of use for me to discuss that opinion with you and the impact it may have in the future on same-sex marriage in the United States. The presentation I originally was planning to do will be online for your convenience when the papers of the conference are published. On May 2nd of this year, a draft majority opinion in Dobbs was leaked to the press. That opinion, which apparently is joined by 5 justices, which would constitute the majority, upholds the limitation on abortion in Mississippi, which prohibits abortions after the 15th week, and overrules Roe versus Wade and Planned Parenthood versus Casey. Alito was appointed to write the majority opinion, and he circulated the draft. That draft presents the court's analysis for overturning Roe and Casey. That analysis may change after discussion by the majority. For our purposes, however, we'll assume that the analysis that Justice Alito gives is the analysis that the court will publish sometime between now and the beginning of July. In 2 instances in his opinion, Alito says that nothing in his overturning of Roe and Casey is meant to affect other Supreme Court precedent concerning sexuality and privacy. What he means is that because Roe and Casey dealt with abortion, and because abortion is a unique act involving the destruction of another life, other precedent concerning, for example, marital privacy, the use of contraceptives, marriage itself, are not affected by overturning Roe and Casey because they're separate. That said, the analysis that Alito uses to overturn Roe and Casey is equally applicable to other so-called privacy cases, including Hodges, which was decided 3-4 years ago, recognizing a right to same-sex marriage. So what I intend to do now is to adopt the framework that Alito uses and apply it to the Hodges case, assuming that the court will be asked to revisit it in the future. The constitutional provision at issue is the Due Process Clause of the 14th Amendment, which states that no state shall deprive any person of life, liberty, or property without due process of law. Although it refers to procedure, at least since 1886 in Mugler versus Kansas, and perhaps earlier than that, the court has applied due process to a matter of substance. So for our purposes, we will read the 14th Amendment as saying that no state shall deprive any person of liberty, contrary to the law of the land. The court, in the standard that Alito uses in Dobbs, a standard the court had recognized when it addressed the issue of physician-assisted suicide in 1997 in Washington versus Glucksberg, a standard that the court had originally developed way back in 1908 in Twining versus New Jersey. First requires the plaintiff to define the claimed right narrowly. That is to limit judicial subjectivity. The problem with judicial subjectivity, the imposition of personal values into the Constitution by the court. The problem, among other things, is that in doing so, the court would impose its own values on the elected representatives of the people without any direct accountability to the populace. So to limit judicial discretion, the first requirement is that the claim be narrowly defined. And here we're talking about a claim to same-sex marriage. Now, Justice Alito says that in pursuing the analysis of whether this is a fundamental right, we must first look, not surprisingly, at the text of the Constitution itself. And of course, nothing in the text of the American Constitution refers to same-sex marriage or marriage generally. The next step is to look at history. And this is where the court has recognized unenumerated rights in its prior decisions. And even Justice Kennedy, who penned the opinion in Hodges, would concede that historically, marriage meant marriage between a man and a woman, not marriage between people of the same sex. So it would be clearly unfounded to say that same-sex marriage is deeply rooted in Anglo-American law. It would be unfounded to claim that it is deeply rooted in any known legal system. The next consideration that Alito gives is precedent. Now, of course, having overruled Roe and Casey, proponents of same-sex marriage could not claim them as supporting precedent. Other cases like Griswold versus Connecticut, which dealt with marital privacy, and Eisenstadt versus Baird talked about the use of contraceptives by unmarried people. Those cases are also distinguishable because they deal with restrictions, not approval. Another example, Lawrence versus Texas, which would be perhaps the most supportive opinion on its face, which dealt with whether homosexual sodomy could be criminalized. And the Supreme Court said, no, it could not. That's distinguishable from same-sex marriage because we're talking there about a criminal prohibition. We're not talking about whether the state has to give affirmative approval to marriage. There's also other cases like Loving versus Virginia that did recognize a fundamental right to marry, but it was marriage between a man and a woman. The idea being that anti-miscegenation laws that prohibited marriage between the races were unconstitutional because they violated the Equal Protection Clause of the 14th Amendment, and fundamentally irrational because race does not undermine the essential aspects of marriage. Man and the woman equal, who can engage in sexual relationships to form one flesh, one spirit, and are designed to be fruitful, so that there is no direct precedent to support same-sex marriage. Finally, Alito discusses the concept of stare decisis, the decision stands. The idea that precedent should not be unsettled, that the judicial day doesn't start anew every time the court addresses the same subject. Obviously, this is to preserve stability in law. But when it comes to stare decisis and a prior constitutional interpretation, the court is more flexible in applying the doctrine, since erroneous interpretations of the Constitution by the court are difficult to remedy. It requires a constitutional amendment, and only 4 times in the U.S. history has a Supreme Court interpretation of the Constitution been overturned through amendment. So it's very difficult to do. And as a consequence, the court applies stare decisis more flexibly when the issue is a prior interpretation of the Supreme Court. The factors that Alito identified in the Dobbs case in determining the applicability of stare decisis is first the importance of the issue involved. It cannot be gainsaid that marriage is important to society and therefore important to our constitutional scheme. I don't think that needs any discussion. Secondly, the quality of the decision under review. Alito spent a great deal of time pointing out the flaws in both Roe and Casey. As for Justice Kennedy's opinion in Hodges, one need only look at Justice Scalia and Chief Justice Roberts' dissent to show how truly unprincipled Kennedy's analysis was, to the point where the Chief Justice concluded his dissent by saying, those people who are in favor of gay marriage can, if they want, celebrate today's decision, but they cannot celebrate the Constitution since it had nothing to do with that decision. So I think one could easily show that, as Justice Scalia indicated, Justice Kennedy's opinion upholding gay marriage was simply incoherent. A third factor Alito looked at was the impact that the decision under review had or would have on other areas of law. And again, going back to the dissenting opinions in the Hodges case, it is apparent that Hodges will have serious consequences on other areas of law. Chief Justice Roberts indicated, for example, that the opinion might support polygamous unions or polyamorous unions, since the limitation of marriage to two people had less support historically, given nations that recognize polygamy, than the requirement of complementarity among the partners. Justice Alito, in his dissent, further indicated that there would be a serious impact on conscience rights, since nothing in the majority opinion recognized that there could be conscientious objection to the recognition of a same-sex union. A fourth consideration is the workability of the prior decision. And I think we can concede that prohibiting states from not recognizing same-sex marriage is a rather straightforward rule. Workable in that sense. It's not like in Planned Parenthood versus Casey, where the Supreme Court said that only undue burdens on the abortion right are unconstitutional. What is an undue burden? What is a burden that significantly affects the abortion right? Those are rather vague terms subject to widely different interpretations given the facts of a particular case. In Hodges, the Supreme Court simply held that all prohibitions against same-sex marriage were unconstitutional. So I think we can say it's a workable test. The final consideration is reliance interests. Alito did not talk about reliance because the precedent is old. There's no mention of people having relied on Roe for the last 50 years. It was decided in 1973. Hodges, of course, was only decided a few years ago. So Alito doesn't seem to be arguing that reliance is a factor of time. He's also not saying that reliance is a factor of social change. The argument was made in the Dobbs case that access to abortion facilitated the increase of women in business and society's career opportunities generally. And Alito responded that whether or not that's true, it's difficult to gauge the impact that Roe itself and Casey itself had on the integration of women into external society outside of the home. And even if it were capable of being gauged, it's a policy decision for the legislature and not the court. Thus, if it were argued that same-sex marriage has increased the integration of gay people in society, I assume the court would give the same response, that ultimately that's a question for the legislature to decide. By reliance, the court is saying, can you show something where specifically practices relied on the decision in order to structure, for example, business arrangements? With that as the frame of reference, Justice Alito said that what reliance interests there are in having pre-viability abortion don't amount to what's required for the application of stare decisis. He said abortion is usually not planned. It's a consequence of having intercourse and then unforeseen consequences from that intercourse. And people who want access to abortion can readily identify whether the state does or doesn't. And if it doesn't, can relocate to a jurisdiction that does. So with abortion, Alito was saying, as for the reliance interest, if it's a question of wanting to go to a jurisdiction where abortion is available, all one needs to do is to check what the state of the legislation is. The same can be said for same-sex marriage. If the Supreme Court overturns Hodges, it's returning the issue to the states, and the states can make their own judgment on whether to recognize same-sex marriage. Some states will, New York, for example. Some states will not, quite possibly Texas. And just with abortion, gay couples can decide what states are more favorable to their perspective. To sum up, even though Justice Alito in the leaked opinion in Dobbs indicated that the overturning of Roe and Planned Parenthood versus Casey would not in and of itself affect other areas like same-sex marriage, the analysis he uses to overturn Roe and Casey is applicable. And a straightforward application of that analysis would, in my opinion, result in the overturning of Hodges.